And so with that, I'd like to welcome everyone to today's online learning session on international humanitarian law and UN peacekeeping operations. As we all know, there are myriad questions related to peacekeeping operations, both legal, policy, and operational for that matter. And so what we're going to focus in on today is at the very basic introductory level, the question of the application of IHL to UN peacekeeping operations. And by starting here, this allows us to establish a very firm grounding on which we can then later analyze and examine related issues related to, let's say, the use of force, to accountability, to potential violations and responses to. So today we're going to start with examining how and under what circumstances IHL applies to UN peacekeeping operations. And to that end, we have a number of learning objectives for today. To begin, we hope that participants will gain a familiarity with the legal bases for the application of IHL to peacekeeping operations, that there will be an increased understanding of when a peacekeeping contingent becomes a party to the conflict, including in the context of force intervention brigades. We hope that you'll gain an appreciation of the various factors to consider when determining whether IHL applies, particularly in the context of a non-international armed conflict. And lastly, we hope to increase awareness of the various challenges raised by circumstances triggering the application of IHL. Here, for instance, we look perhaps to the temporary loss of legal protection under the Rome Statute. And so with that, it is my pleasure to introduce to you Katarina Grenfell. Katarina is a legal officer with the UN Office of Legal Affairs. And with that, I will turn it over to Katarina.
Good morning to everyone. I'd like to thank the organisers of PHAP for inviting me to speak on this issue today. It's a pleasure to be here with you. The first thing I'd like to say is that this morning I'm speaking in a strictly personal capacity, and that anything I say may not necessarily reflect the official position of the United Nations. Today in my presentation, I'd like to give you an overview of the main issues which relate to the application of international humanitarian law, or IHL, to UN peacekeeping operations. As Elizabeth has mentioned, this is an issue which seems to be becoming increasingly topical in light of a trend not only of more robust peacekeeping mandates, but also in light of a trend of increasingly difficult and hostile environments in which peacekeepers are being deployed. And in this regard, it is clear that a number of peacekeeping operations are currently deployed in environments where there is little or no peace to keep and are mandated with extremely challenging tasks. Before I continue, I'd like to emphasise that today I will only be talking about UN peacekeeping operations, which are operations conducted under UN command and control. And this is in contrast to UN authorised operations, which are military operations authorised to use force by the Security Council, but are conducted under national or regional command, such as ISAF in Afghanistan or NATO action in Libya. These are generally referred to as peace enforcement actions. Now, I know that some would say that it doesn't matter whether we are talking about UN peacekeeping operations or UN authorised operations, as IHL applies based on the facts on the ground, rather than the categorisation of the force or the reason for the use of force, which argument, of course, is based on the fundamental distinction between the jus ad bellum and the jus in bello. And just briefly on this, the jus ad bellum concerns the right to use force under public international law, whereas the jus in bello is the law which governs the conduct of hostilities and is referred to as international humanitarian law or the law of armed conflict. And in accordance with the principle of equal application, the reasons for engaging in armed force, the jus ad bellum considerations, are to have no bearing on the application of the jus in bello. As Sir Hersch Lauterpacht, a famous international lawyer, said back in 1952, It is impossible to visualize the conduct of hostilities in which one side would be bound by the rules of warfare without benefiting from them, and the other side would benefit from the rules of warfare without being bound by them. So while this principle may seem straightforward, in my experience, it generates a lot of debate whenever this issue is discussed in the particular context of UN operations. And as we are talking about the application of IHL to UN operations, I'd like to take a moment to explain why this issue is significant, both as a political and a practical matter in the context of UN operations. So IHL applies to UN operations when they become a party to an armed conflict. And I'll talk about that later, and the threshold for that to occur. But for now, I'd like to mention that there's a certain amount of unease, including among troop contributing countries, or TCCs, as I might refer to them, who provide personnel to serve in UN operations, that a UN peacekeeping operation may be considered a party to the conflict. This is partly on the basis that, in accordance with the three core principles of peacekeeping, which are consent of the parties, impartiality, and the non-use of force, accepted self-defence or defence of the mandate, UN peacekeeping operations are to operate in accordance with the principle of impartiality. As such, referring to a UN operation as a party to the conflict seems at odds with this principle, and notwithstanding that peacekeepers act under unified UN command and control, it may cause discomfort for the TCCs concerned. In addition, and very importantly, there is also the consequence that if the UN were regarded as a party to an armed conflict, UN military personnel may be considered as legitimate military targets. Civilian personnel may also lose their protection as civilians if they engage in activities which constitute direct participation in hostilities, and civilians may well also constitute collateral damage if the UN operation and its facilities are attacked. In my view, this is a real concern for the organisation and for TCCs, particularly against the background that UN peacekeepers don't act on the basis of national interests, but pursuant to a mandate from the international community. TCCs may be less willing to participate in UN operations where there are these kinds of implications. Now, coming back to robust peacekeeping mandates and difficult environments, the most significant recent development with regard to the use of force by UN peacekeeping operations is the establishment of the Intervention Brigade as part of MONUSCO, the UN's peacekeeping operation in the Democratic Republic of the Congo. The Intervention Brigade was established by the Security Council in Resolution 2098 to 2013 to be a special combat force within MONUSCO. Acting under Chapter 7 of the UN Charter, the Council authorised MONUSCO and the Intervention Brigade to take all necessary measures to carry out targeted offensive operations, either unilaterally or jointly with the FARDC, in a robust, highly mobile and versatile manner to prevent the expansion of all armed groups, to neutralize these groups and to disarm them. As you can tell from the language of the resolution, MONUSCO has been given an unambiguous mandate to carry out offensive military operations in order to neutralize armed groups, which is clearly more of a peace enforcement task than a traditional peacekeeping task. While this isn't the first time that a peacekeeping operation has been tasked with a robust mandate, it provides strong contrast to the more traditional forms of peacekeeping in which peacekeepers may be unarmed or are only authorised to use force in self-defence or defence of the mandate, and who usually perform mandates such as monitoring the implementation of a ceasefire or a peace agreement. That said, it's now increasingly common for peacekeeping operations to be authorised to use force in order to carry out mandates, such as, for example, to protect civilians under imminent threat of physical violence, to conduct stabilization activities, to protect UN and humanitarian personnel, to allow unimpeded humanitarian relief, or to create secure conditions to allow national elections to take place. And when UN peacekeeping operations use force, whether pursuant to a robust mandate like that of MONUSCO or for any other reason, the question that arises is whether the use of force is of such a nature as to trigger the application of IHL. And if so, what are the consequences of the application of IHL? In addressing these questions, I will examine the following issues. Is the UN bound by IHL? And if so, how? In what circumstances does IHL apply in respect of UN peacekeepers? What are the consequences of a UN operation becoming a party to a conflict? And when IHL applies, where does it apply? And when does it stop applying? That is, what is its geographical and temporal scope of application? Finally, what protections are there in international law for UN peacekeepers? So coming to the first of these, is the UN bound by IHL, and if so, how? The UN isn't a party to the Geneva Conventions and their additional protocols, and as such, isn't formally bound by them. However, as clarified by the International Court of Justice in the reparation case, the UN is a subject of international law and is capable of possessing international rights and duties, including under customary international law. And regarding the nature of the UN's obligations, the ICJ emphasised that the duties of the UN in respect to international law depend on the purposes and functions as specified or implied in its constituent document and as developed in practice. Peacekeeping is of course not referred to in the Charter of the UN, but has developed in the practice of the organisation to allow it to carry out its purpose of maintaining international peace and security. As such, consistent with the ICJ's reasoning, to the extent that UN peacekeepers may be regarded as combatants in situations of armed conflict, the UN would be bound by the principles and rules of IHL, which apply via customary international law. Importantly, as a matter of policy, the UN has also formally acknowledged that it's bound by IHL. This dates back to 1963, when the Secretary-General issued regulations in respect of ONUC, which was the peacekeeping operation in the Congo at the time. More recently, in 1999, Secretary-General issued an internal instruction known as the Secretary-General's Bulletin on the observance of UN forces of international humanitarian law, which clarified that IHL may apply in respect of UN forces. The Bulletin makes it clear that certain fundamental principles and rules of IHL are applicable to forces when, acting under UN command and control, they are actively engaged as combatants in situations of armed conflict. As such, the Bulletin removes any doubt that forces acting within UN peacekeeping operations may be bound by IHL when acting pursuant to a UN mandate and under UN command and control. In addition to the issuance of the Bulletin, it's also become standard practice that the UN concludes status of forces agreements, or SOFAs, with states hosting peacekeeping operations. And these contain provisions requiring both the UN and the host state to conduct any military operations with full respect for the principles and rules of IHL, including those set out in the Geneva Conventions and the additional protocols. So in what circumstances does IHL apply in respect of UN operations? As you probably know, IHL doesn't apply in respect of mere riots or sporadic violence. In these situations, domestic law applies. But it does apply whenever there is a situation on the ground that meets the threshold of an armed conflict. This occurs when peacekeepers engage in armed hostilities of such intensity as to trigger the application of IHL, whether via acts in self-defence or in the course of carrying out a particular mandate authorised by the Security Council, such as the protection of civilians. And as UN peacekeeping operations are usually deployed with the consent of the host state, it's unlikely that a UN operation would engage in an armed conflict with a state, but rather against a non-state actor. And as such, I'm going to focus on the threshold which applies in respect of a non-international armed conflict. The threshold for a non-international armed conflict involves two general criteria, that must be satisfied based on the facts on the ground. The first of these is that the hostilities must reach a certain level of intensity, and the second is that the armed group should possess a certain minimum level of organisation. Regarding the first, whether the hostilities have reached a minimum level of intensity, this can be determined by indicators such as the duration of the combat, the type of forces which have been mobilised, the number of fighters and troops involved, the types of weapons used, the number of persons detained or wounded, the extent of damage caused by the combat, and the geographical extent of the military operations. Regarding the second, the level of organisation of the armed group, this can be determined by indicators such as the existence of a chain of command, its capacity to transmit and enforce orders, its ability to plan and launch coordinated military operations, and its capacity to recruit, train and equip new fighters. However, in practice, it can be difficult to determine when this threshold is met. I should mention that the ICRC, the International Committee of the Red Cross, has also proposed a support-based approach. I won't go into detail about it now, but in a nutshell, as I understand it, the ICRC support-based approach takes the position that when the UN provides support to government forces already involved in a pre-existing non-international armed conflict, whether it be in the form of logistical support, intelligence, or support in planning or coordinating the military operations of the state, that where those actions contribute to the collective conduct of hostilities, the UN operation should also be considered a party to the pre-existing non-international armed conflict. In light of an increasing trend of UN operations being mandated to provide logistical and other forms of support to both national and international forces conducting military actions against non-state actors, such as in Mali and Somalia, this can have serious implications for the conduct of UN operations. And as such, the basis for its applicability and the implications thereof must be fully understood. So what are the consequences of a UN operation becoming a party to a conflict? Well, first and foremost, when IHL applies, members of the military contingents of the UN force, together with military objects, would be considered legitimate military targets. Civilians, which would include the civilian staff of the peacekeeping operation, together with the UN police and any unarmed military observers, would be entitled to protection as civilians unless they take a direct part in hostilities. And while it's not altogether clear what constitutes taking a direct part in hostilities, certain activities which support the conduct of hostilities, depending on their nature, such as military planning, may entail that civilians who undertake them might be considered as amounting to taking a direct part in hostilities. And to the extent that civilians take a direct part in hostilities, they would lose their protected status and be considered a legitimate target. Also, if the UN were to provide logistics support for combat operations by other forces, many of the objects related to logistics support, for example, fuel and transport and depots, could also be deemed military objectives insofar as they would make an effective contribution to military action. As such, civilians involved in handling or transporting such objects would also be at risk of attack. The requirement that UN forces comply with IHL also has a number of other practical consequences for the organisation. And just briefly, these include the obligation of providing training of UN peacekeepers in IHL, the obligation of ensuring the proper conduct of peacekeepers when they're deployed in UN operations, including proper application of the rules of engagement of the operation, the application of the human rights due diligence policy to ensure that when UN forces provide support to national armed forces, the UN doesn't in any way aid and abet violations of human rights law and international humanitarian law by the national forces. It also requires observing standards and procedures as required by IHL in the event that UN forces might detain persons whilst carrying out their mandate, and also addressing issues of responsibility when UN forces violate IHL, including by following up with member states to ensure that investigations are being conducted and that prosecutions have been conducted where appropriate in respect of violations of IHL by their members. This now brings me to the geographical and temporal scope of application. What are the geographical boundaries of IHL application in situations where UN peacekeepers may be regarded as a party to the armed conflict? Would UN peacekeeping forces be subject to IHL within the entire territory of a state to which they're deployed? Or would they only be subject to IHL in the areas where they engage in active hostilities? Also, how long would IHL apply in respect of peacekeepers? Would it only apply while they actually use force? Or would it apply in respect of them until the end of the conflict in which they're being deployed? These questions are important as peacekeeping forces are usually mandated to carry out a range of different types of tasks throughout the host state, and not all military contingents will operate in the same kind of environment within the territory of the host state, which may be very large. For example, in the case of Mali, there could be a situation where some military contingents of MONUSCO are attacked by armed groups and subsequently become engaged in sustained combat in one region, whereas other military contingents in another region may be positioned around a town to carry out their mandate to protect civilians or to protect the delivery of relief supplies. In such a case, with the latter military personnel who are protecting civilians or protecting relief supplies also be regarded as lawful targets, just as the military personnel engaged in combat with the armed groups. Similarly, the temporal scope of application of IHL is important because it establishes when military personnel of the force regain the protection given to civilians and cease to be lawful targets under IHL. While these issues are largely theoretical, as in practical terms, peacekeeping operations will take measures to protect their personnel once the mission considers that it's under threat within the host state, they do go to illustrate some of the debates about the application of IHL in the particular circumstances of UN peacekeeping operations. They have important implications in terms of how the operation should comport itself and what legal framework the operation would need to apply, such as, for example, if it detained persons in the course of carrying out its mandate. So this now brings me to the final part of my presentation. What protections are there in international law for UN peacekeepers? The basic legal protection framework is provided by the 1994 Safety Convention, the Status of Forces Agreement, and the 1998 Rome Statute of the International Criminal Court. I won't read out what's on the slide, but I would like to address this by highlighting two different situations. In the first situation, the UN peacekeeping operation is deployed to a state where there is an armed conflict which is already ongoing, but the peacekeeping operation is not involved in the armed conflict, or not in such a way as to render it a party to the armed conflict. In the second situation, the UN peacekeeping operation is regarded as a party to an armed conflict. In the first situation, as the UN operation is not a party to the armed conflict, the members of the operation, including military personnel, are entitled to the protection given to civilians under IHL. Therefore, the members of the peacekeeping operation are not lawful targets and must not be the object of attack. This is a rule that is applicable in both international and non-international armed conflict, as confirmed in the Rome Statute. The members of the peacekeeping operation are also protected by the Safety Convention if it's applicable in the host state, and usually it's made applicable by the Status of Forces Agreement. Status of Forces Agreement also puts an obligation on the host state to provide security for the peacekeeping operation. It's a war crime under the Rome Statute to attack peacekeepers in such situations. Regarding the second situation, to the extent that a UN peacekeeping operation comes to be regarded as a party to the armed conflict, the military members of the UN operation would no longer enjoy the protected status of civilians, and civilians may be targeted as if and to the extent that they take a direct part in hostilities. Here it would seem that the Safety Convention would still apply. However, that causes some difficulties in terms of the principle of equal application that I discussed at the beginning of the presentation. In this regard, I should mention that there's a disconnect between the Safety Convention and the Rome Statute with respect to protection in situations in which a UN operation has come to be regarded as a party to a non-international armed conflict. While the Safety Convention continued to provide protection in these situations, the Rome Statute would not. The Rome Statute doesn't distinguish between situations of international and non-international armed conflict. Under the Rome Statute, the protected status of peacekeepers will be lost in both situations of international and non-international armed conflict, to the extent that the UN operation has come to be regarded as a party to the armed conflict. While this creates some confusion in the international law framework, in my view, it would be advisable for UN operations to be guided by the terms of the Rome Statute. And this is because the Rome Statute was adopted after the Safety Convention and has been ratified by over 120 states, and as such probably represents the current position of states on this issue. It would also be advisable for UN operations to make it well known within the host state that they're fully committed to respecting IHL where it applies, so as to induce armed groups to respect IHL vis-à-vis UN operations, including with respect to protecting the civilian personnel of the UN operations, as well as the ordinary civilians of the local community. Now, this brings me to the end of my presentation. I hope it's given you a good overview of the range of legal issues that arise in this area, and I turn over to Elizabeth for the question part of the session. Thank you.
Thank you very much, Katarina. That was a very helpful and insightful presentation. I think it provides all of us a very solid grounding to better understand this topic, as well as to explore and examine related issues in future sessions. So again, thank you very much. I will now be online soon. And as a reminder, the recording of today's event will be available online, and the link to a number of articles, including that referenced by Katarina, the very excellent article by Tristan, is available on the website, as well as the article also written by Katarina herself, which is a very helpful guide to these questions. So please do check out the resources available online. And of course, for those of you who are interested, the assessment will be available immediately following today's event. And with that, I will sign off, wishing everyone a good morning, good afternoon, or good evening. And thank you to everyone, and hope to see you back online again soon.